Hello everyone and welcome to Narayana IAS Academy. As part of our weekly current affairs revision, we'll be delving into 6 significant topics from Hindu and Indian Express. Let's thoroughly examine all these topics one by one, ensuring we are covering all essential details to keep you well informed and prepared. Let us start with the first topic.
The first article for the day is oath taking in the Lok Sabha. So in this particular article, we'll be discussing about how significant and important is this particular practice of taking oath, specifically for the recently elected MPs of the Lok Sabha. And also we'll be looking into the historical origin of this particular practice as well as the relevant constitutional provisions with respect to the same. So in this particular article, we'll be discussing about this particular process of oath taking in the legislature as well as it is a part of the Indian Constitution. And we can map this entire topic to polity under prelims examination, and for the mains examination, it can be mapped to GS paper 2, salient features of the Indian Constitution, union and state legislatures. So moving on to the previous year question, there has been a question in the year 2012 regarding the office of the Lok Sabha Speaker. Consider the following statements. So these kind of constitutional offices, the eligibility criteria as well as the functions, the objectives as well as the allowances and the salary that they actually get is all very important for your prelims examination in particular. Now let us understand what this particular news is talking about. So, as the first session of the 18th Lok Sabha begins today, newly elected members of the parliament, that is the MPs, are set to take their oaths, which is a critical constitutional requirement before the House that can actually start its legislative functions. So, moving forward, let us understand when does the term of an MP begin, okay? So, the 5-year term of a Lok Sabha MP begins when the Election Commission of India actually declares the results as stipulated under Section 73 of the Representation of People Act 1951. Moving forward, from this particular day, the Member of Parliament are entitled to their rights as elected representatives, which includes receiving salaries and allowances from the day of the Election Commission of India's notification. Moving on, this commencement of the term also subjects these MPs to the anti-defection law, which allows their political party to request disqualification if they change their allegiance towards the particular party, that is the current party which they have been elected from. Okay. Now, significance of this particular practice of parliamentary oath. First one, despite the start of their term, winning the election and commencing the term does not automatically enable an MP proceedings. Okay, just winning it and being declared as a winner does not mean that this person is actually automatically enabled to participate in the proceedings of the House, to debate and to vote in the Lok Sabha. An MP must take their seat in the House by making and subscribing to the oath or affirmation, which is actually mentioned in Article 99 of the Constitution. Also, participating or voting in the House proceedings without taking an oath actually incurs a financial penalty of ₹500, which is actually specified under Article 104 of the Constitution. Also, however, there is an exception. That is, an individual can become a minister even without being elected to the parliament, and this particular person must secure a seat in either the Lok Sabha or the Rajya Sabha within a period of 6 months, and during this period they can participate but they cannot vote in the proceedings of the House. Moving on, let us actually understand the parliamentary oath, how it is actually given. So, the Constitution's 3rd schedule contains the text of parliamentary oath, and here it reads, I, so and so, having been elected or nominated a member of the Council of States or the House of the People, do swear in the name of God or solemnly affirm that I will bear true faith and allegiance to the Constitution of India as by law established, that I will uphold the sovereignty and the integrity of India, and that I will faithfully discharge the duty upon which I am about to enter. So this is actually the oath that the particular elected MP actually takes. Okay. Next one, evolution of this particular oath. The draft constitution, which was prepared by the drafting committee and which was chaired by Dr. B.R. Ambedkar, initially did not invoke any particular term as God in any of the oaths. The committee emphasized a solemn and sincere promise to bear faith and allegiance to the Constitution of India only. However, during the Constituent Assembly discussions, there were certain members like K.T. Shah as well as Mahavir Tyagi. They proposed the amendments in order to include the term God on the oath, arguing for the liberty of the believers to swear in the name of God while allowing the agnostics to solemnly affirm. Also, Ambedkar had actually accepted these amendments, recognizing that for some, invoking God provides the necessary moral sanction for fulfilling their duties as well as the obligations. And then moving on, the last significant change to this particular oath-taking practice actually came with the Constitution 16th Amendment Act of 1963, which added a commitment in order to uphold India's sovereignty and integrity, which were actually based on the recommendations of the National Integration Council. Moving forward, now let us understand what is this procedure for taking the oath, okay? So before taking up the oath or the affirmation, the MPs must submit their election certification to the Lok Sabha staff. And this safeguard actually was introduced after a 1957 incident where a mentally unsound individual posed as an MP and took the oath. So this is actually, it should not be allowed. Then MPs can take the oath or affirmation either in English or any of the 22 languages that is actually specified as per the 8th schedule of the Constitution. Also, MPs must use the name mentioned in their election certificate and must adhere very strictly to the text of the oath. And also, deviations such as adding suffixes or additional phrases are actually not permitted, as seen when the recently BJP MP, whose name was Sadhvi Pragya Singh Thakur, added a suffix to her name in 2019. And the Rajya Sabha MP Swati Maliwal actually ended her oath with Inquilab Zindabad in 2024, both of whom were asked to retake their oaths, okay? So this is actually not allowed. Adding prefixes or suffixes to the oath or any kind of deviations from what has been mentioned in the election certificate is actually not allowed. And also now looking at a personal choice, whether oaths and affirmations, that is, you can actually choose between the two. Let us see. Oaths and affirmations are a personal choice for the MPs, and in the Lok Sabha, 87% of MPs swore, that is in the previous Lok Sabha, 87% of the MPs swore in the name of God, while 13% affirmed their allegiance to the Constitution of India, and MPs have sometimes chosen to swear in the name of God in one term and affirm in another. So it is totally, the discretion of the person who's elected to power. Now let us understand what is the difference between the oath and affirmation, okay? An oath and an affirmation serve the same legal function of pledging truthfulness or commitment to the duty, but they differ in the invocation of a higher power, okay? So an oath is nothing but it is a solemn promise to fulfill one's duties or tell the truth, typically invoking a deity, reflecting the individual's religious beliefs. Whereas if you actually take affirmation, it is a solemn and formal declaration made without any kind of religious reference. That is, deity or God is not involved here, used by individuals who prefer a non-religious pledge or who do not believe in a particular deity. And also, now let us understand what is actually the case of oath taking by the MPs who are actually in jail, okay, or who are sentenced to a jail term. The Constitution specifies that if an MP does not attend the Parliament for a period of 60 days, their seat can actually be declared vacant. And also, the courts have allowed the MPs in jail to take their oath in the Parliament to comply with this requirement. For example, if you see, during the oath taking for the last Lok Sabha in June 2019, Atul Kumar Singh, an MP from Uttarakhand, who was in jail for serious criminal charges, was permitted by the court to take his oath in January 2020.
Students, the title of the next topic is Srinagar gets tag of World Craft City, right? So this is important from art and culture, and this can be important for prelims as well as GS paper 1. So, previous question, safeguarding the Indian art heritage is a need of the moment, was a question asked in the year 2018. So, the topic that we shall be discussing can be used as an example to address such type of questions. Now, Srinagar has been recognized as World Craft City by the World Craft Council International. Now, apart from Srinagar, Jaipur, Mallapuram and Mysore are the other cities recognized by the World Craft Cities, or they are recognized as World Craft Cities. Now, this World Craft City Students initiative is spearheaded by World Craft Council. Now, World Craft Council is an international organization deciding, or the aim, the motto is to promote traditional crafts and artisanship world. So here the art is being promoted, right? So the goal of the World Craft Cities designation is to recognize and celebrate cities that have rich heritage in crafts and handmade arts, thereby promoting cultural exchange, tourism and economic development. So the point is to promote trade, right? So the cities which are rich with a cultural legacy, or let's say heritage in crafts and handmade arts, such cities are being or given recognition globally. So what are the benefits? One, you get a global recognition, which means of all the countries, the city that gets a tag will get a global recognition. Second, tourism will get a boost. So looking at the importance of the arts or craft of that particular city, many people will visit that city, and thus tourism will be boosted. Economic development. Now the artisans, right, the art that they make or create, they can ensure that their products have a wider market. Why? Because that the city is getting recognized globally. And then cultural exchange. Now all the World Craft cities can collaborate and exchange programs. This is how the global understanding and appreciation of diverse craft traditions can be fostered, right? So these are the benefits. Now talking about the World Craft Council, now this is a non-profit, non-governmental organization that promotes traditional crafts globally. This World Crafts Council was founded in 1964, and very important point is it is affiliated with UNESCO, which is a part of United Nations. And this is organized in 5 regions. One is Africa, Asia Pacific, Europe, Latin America and North America, right? So this is the World Craft Cities and the World Craft Council International. So this can be asked in the prelims examination. So make sure that you know this particular cities under the World Craft Cities. I hope you understood this article.
The next article that we'll be discussing about is post of the Deputy Speaker. So in this particular article, as the 18th Lok Sabha has actually resumed its session, the opposition is actually hopeful that one of the members of the opposition parties will be appointed as the Deputy Speaker. So in this particular article, we'll be discussing about the post of the Deputy Speaker, as well as is a very important topic from the Parliament, because even if you see in 2024, there have been a number of questions on the, Parliament, that is the passage of the bills or the appointment of the Speaker or the powers of the Speaker. All these are very, very important, specifically for your prelims examination, and it is under Polity and Governance. We can map this particular topic to the prelims examination, and for the mains under GS paper to Parliament. So moving forward, there has been a question in the year 2017 with respect to that of the Lok Sabha and the State Legislative Assembly. So this entire concept of legislature, whether it is in the center or in the state, becomes very important for your prelims examination. Now let us understand what this particular article is discussing about. So the opposition has been anticipating, or it is very, very hopeful in order to get the post of the Deputy Speaker in the Lok Sabha due to its increased strength when compared to that of the previous elections. Okay, so there was no Deputy Speaker during the 17th Lok Sabha, that is from the period of 2019 to 2024. There has been, no Deputy Speaker, and Mr. M. Thambidurai of the AIADMK was the Deputy Speaker of the 16th Lok Sabha, that is from the period of 2014 to 19. And now the opposition held the Deputy Speaker post continuously from the period of 1990 to 2014. So in the backdrop of this, it is expected that one of the members from the opposition will actually hold the post of the Deputy Speaker. So here, let us understand what is this election process of the Deputy Speaker. So here, no specific time frame in the Constitution for the appointment of the Speaker and the Deputy Speaker is actually given. And also, use of the term shall and as soon as may be, this actually indicates mandatory and the prompt appointments of the Speaker. But however, a tenure of 5 years or a period of 15 days, that is actually not mentioned in the Constitution. And also, the Speaker is usually elected in the first session of the new House. That is, in the first session or the meeting of the new House, there will be election for the appointment of the Speaker. And also, the Deputy Speaker is usually elected in the second session. And here, Rule 8 of the Lok Sabha rules, or it actually governs the Deputy Speaker election. Now moving forward, let us see what are the constitutional provisions that are associated with that of the Deputy Speaker. So Article 95 Clause 1 actually says that Deputy Speaker performs the Speaker's duties if the post of the Speaker is actually vacant. And as per Article 93 of the Constitution, the House must choose a Speaker and the Deputy Speaker as soon as may be. So here again we actually discussed that no specific time frame is actually mentioned, and as per Article 178 of the Constitution, similar provisions for the state assemblies is actually given. So this is actually towards the center, and 178 declares, talks about the provisions for the appointment of Speaker and Deputy Speaker in the assemblies. Now coming forward, let us understand what are the functions and powers of the Deputy Speaker. So here the Deputy Speaker presides over the proceedings of the House in case the, the post or the seat of the Speaker is actually absent, that is vacant. And this includes all the duties, the responsibilities and the powers of the Speaker. And also the Deputy Speaker assists the Speaker in administrative matters related to the functioning of the House. And in case of a tie during the voting, the Deputy Speaker, when presiding, has the casting vote to break the deadlock, and this is what the Speaker also possesses. And also the Deputy Speaker, in the absence of the Speaker, can certify whether a bill is a money bill or not. This is very, very important because these are, very static but still tricky statements that can be asked in your, as a one-liner in one of the statements in your prelims examination. Okay, so this is what is the duties, the power functions, as well as the constitutional provisions with respect to that of the office of Deputy Speaker.
If we talk about the fourth article of the day, it is related to environment. And there are so many keywords here which we have to pay attention to, like Banerghatta National Park. UPSC asks questions on National Park. They ask questions on biosphere reserves rather. They ask questions on wildlife sanctuaries. Then they ask questions on different kind of flora and fauna. So India's largest leopard safari opens at Banerghatta National Park. Where is Banerghatta National Park? Karnataka. And this is the first, this is the largest leopard safari. So now we also need to understand what is happening with leopard. What is the IUCN status of leopard? So there are so many critical areas, important areas, which we need to cover in this particular article. Like you can see here, in 2015, they have asked about a national park where the climate is varying from tropical to subtropical, temperate and Arctic. So these kind of questions they ask. National park you have to cover, especially those national parks which are in news, right? So Karnataka Environment Minister inaugurated South India's first and India's largest leopard safari. So we have leopard safari, but this is South India's first leopard safari in Banerghatta National Park. And this is India's largest leopard safari. So there are so many keywords here in Banerghatta Biological Park. And this is in Karnataka, right? Now, you have to also understand, like Banerghatta National Park, where is it located? Which river is adjacent to it or near it? So many keywords we have to pay attention here. So more in news, due to rising human-animal conflicts, the park rescues leopard cubs and nurturing and relocating them to the safari. And they have included separate areas for leopard cubs, skywalks, and a plan to connect the zoo. So these are some description of the leopard safari, what will be happening here. But more important than the previous slide is this particular slide. Where is it located? Banerghatta National Park, Karnataka. We have seen which hill range, Anikal range, right? And then what are the other important areas here? First, India's first butterfly enclosure. Everything first, your first love, your first friend. Everything first becomes very important. So India's first butterfly enclosure was inaugurated in this park. First or largest leopard safari, first butterfly enclosure. You can see so many keywords here. And which river is adjacent to this Banerghatta National Park? And this is not only adjacent, this is running through the center of the park. Suvarnamukhi stream. So what they can do, they can tell you that there is a particular national park which is through which Suvarnamukhi river is flowing, and it is located near in the hills of Anikal range. Which national park we are talking about here? So these kind of questions they can frame. So that's why these points become important. And the more question you solve, the more you understand which kind of questions UPSC can frame. Banerghatta National Park, you have Banana County Resort, all these resorts. So again, to promote tourism, Dodamakli Nature Camp, River Turn Lodge, all these things are there. And again, why we have included this particular image? To make you feel like, okay, generally what happens when you're reading stuff, so you will be remembering less. But when you're seeing images, the things will be getting etched in your memory much faster. So that is the purpose why we have included this particular image. Now, we have done with one major part of this particular article regarding Banerghatta National Park, which river is running through the center of the park, which hill range, is surrounding it. Now the second part about the leopard status. So Indian leopard is a subspecies of the leopard and widely distributed on the Indian subcontinent, threatened by illegal trade, like most like tiger, lions, all these things, they are threatened by illegal trade. And what is the conservation status? Vulnerable. They are classified as vulnerable by the IUCN Red List. Now, one more important thing in this particular slide. Schedule 1 of WPA 1972. First of all, WPA, when was it passed? 1972. Environmental Protection Act, when was it passed? 1986. To have a look at that. Then there are different schedules on which UPSC has already asked PYQ. Schedule 1, Schedule 2, Schedule 3, Schedule 4, 5 and 6. So again, the homework is, once you are done with this particular lecture, this video, you have to read all these schedules from 1 to 6. India's leopard population is estimated at 13,000. Again, you don't need to remember all these data, just understand or keep in mind that the population is increasing. That means the population is stable. India's leopard population is stable, right? And what is the IUCN status? Vulnerable. Schedule 1, they are listed because sometimes they will give you the question that Indian leopard is listed in Schedule 3, that is wrong. Then you have to see what is Schedule 1 and Schedule 2, Schedule 3 and Schedule 4, Schedule 5 and Schedule 6. Leopard status, again, this is the factual information, but this is actually important. Sometimes they do ask in which state you have maximum number of leopards, that is in Madhya Pradesh, followed by Maharashtra. So this also is an important fact which you need to keep in mind.
Let's start with the next article, that is larger academic interest behind Bombay High Court's hijab ban decision. So in this, we will discuss the two conflicting ideas. That is, number one is the freedom of religion, and number two is the idea of secularism that educational institution is trying to promote, which comes under the paper 2 and 3. That is the basic features of the Indian Constitution. And often the question is being asked from this particular part of the polity. Like even previously in 2019, UPSC has asked the question, which article of the Constitution of India safeguard one's right to marry the persons of one choice? 19, 21, 25 or 29. So just think about it. In meantime, let's move on to the article. Now, why are we talking about this? Why is this in news? This was in news recently because in 2024, the Chembur College implemented a dress code which actually banned any kind of religious identifier. So whenever you are wearing a dress, the religious identifier was completely banned. And that include like burqa, niqabs, hijab or any other kinds of thing that identify you as belonging to one particular community were banned. Be that for boys or that for the girls as well. Now, once that happened, the college implemented the ban. The student went to the judiciary by saying that is actually violate their fundamental right under Article 19 and 25. Now, the Bombay High Court actually went in the favor of college or the educational institution by saying that the new dress code is in the larger academic interest of student. So, it is this particular news that we are going to analyze, that why Bombay High Court took the decision in favor of the college. Moving on to, first of all, what was the argument? Like, we will talk about both the argument in favor and against. In favor, the argument is coming from the student, which says that the dress code is particularly arbitrary and discriminatory because by banning the hijab and niqabs are prohibiting the Muslims to practice the essential religious practices, which comes under the doctrine of essential religious practices that we will discuss just in a few minutes. And thus, by imposing such kind of restriction, they are taking away their fundamental right under Article 19, which has given them the freedom of expression, and Article 25, which gives them freedom of religion of the Constitution. And thus, the third argument given by them is that it's a contravention to UGC guideline, which promote equity in higher education. And this is the argument that is given by the student, that it's discriminatory, it takes away the freedom of right, the fundamental rights, and it actually contravenes the UGC guidelines for equity in higher education. Now, what is the argument that is given against, like those who do not favor the hijab and other religious identifier in college institutions? Number one, the first argument comes from the administrative or the institute itself, which says that there is a need of uniformity in school. They say the school is a place which promote rationality, which promote objectivity, and thus school has to be a place where student can rise above its religion. And thus the institute says that by applying a uniform code, they're actually preventing the discrimination. They are promoting uniformity among all the students regardless of what religion they belong to. So the educational institution says that we are promoting uniformity by having a single code for all of them. It does not discriminate based on religion. Second is, it says that this is actually promoting objectivity by preventing student to disclose their religious identity, and thus they can entirely focus on education instead of focusing on their religion. And in their education, they can focus on the values of rationality, objectivity, and maintaining a larger discipline in the school institution. And third, the administrative institution has said that there has been a legal precedent. Even the Karnataka High Court in 2024 had says that the wearing hijab is not an essential religious practices, and thus they are not discriminating against any community. Also, so this was the argument in favor that was given by the institution. The second argument comes from the Bombay High Court, which says that by doing so, they are not infringing on the fundamental right of any community or individual, because Article 19 as well as 25 has given are subjected to reasonable restriction in the interest of public order, morality and health, and thus to promote the larger academic interest, to promote the rationality, objectivity and uniformity in school has every right to impose such kind of a ban. It's not an absolute right. Article 19 and Article 25 are not absolute right. This is what you're going to remember over here. Again, the High Court has also says that by preventing the revelation of religious identity of a student, that actually takes away the focus of a student from the religion to now education, which is a more utmost requirement of education, and thus they can promote uniformity, constitutional secularism, rationalism, and other desired value in the education. And thus the High Court says that this code actually does not promote discrimination, instead it promotes uniformity. And High Court also lastly favors the argument that there's not enough evidence in favor of hijab being an essential religious practices in case of Islam. Now, since we have discussed essential religious practices a lot, we need to know what are essential religious practices. The doctrine of essential religious practices was given by the Supreme Court. It's actually a judicial invention which came by the 7-judge bench in 1954 in Shurur Mutt case. So 7-judge bench came up with this doctrine of essential religious practices, which says that they define the term religion encompasses all ritual and practices which are integral to the religion. So any ritual and practices that are integral to the practice of religion are considered as they encompass the religion. So doctrine has allowed this doctrine has helped judiciary. It has given them a tool to safeguard religious practices which are considered as essential and integral to religion. So if any practices is essential, that means without which the religion cannot stand. This was the basic foundation of a religion. The judiciary can actually try to protect this. So under this doctrine, they were actually protecting this such kind of essential practices. But you should remember, there is no objective criteria behind that. Often, what is essential, what is not, is left at the discretion of a judiciary. That which judge favor that this is essential practices and which is not. And you can see in several cases, the same thing has happened in case of Indian judiciary as well. Hijab has been declared as essential practice several times, and several times it is not. So there is lot of variation in terms of the judgment. But overall, this doctrine has originated from the speech that is given by Dr. B.R. Ambedkar in Constitutional Assembly that advocated that there is a need of state intervention in matter related to religion, in matter where it is not inherently religious. That means if any religious practices is not the basic foundation of religion, it is not important, without this religion can stay, its basic tenets can stay, then state can easily intervene in that. So that was a doctrine of essential religious practices. So overall, in this article, what Bombay High Court has done this, it has upheld the hijab's ban on the Chembur College, prioritizing the institutional's right to maintain discipline and uniformity over the individual's dress preference, and emphasizing the focus on the academic environment against the need to show your religion at every place. With this, we're done with this article. Now let's move on to the next one.
If we talk about the second article of the day, this article, although there are so many factual information here, you have to understand it from the point of view of haphazard urbanization and GS1 urbanization, right? And then you can correlate what is happening in Delhi, and currently even in Gujarat, I think the airport certain structure has fallen down. So what is happening in Delhi, or let's say in certain areas of Gujarat, you can equate it with what has happened earlier in Chennai or in Bangalore. So many things are happening, and these are examples of haphazard urbanization, unplanned urbanization, restless exploitation of resources in urban areas, right? So we have to keep this in mind and we have to learn from it. Plus, lack of planning and coordination among different entities. Like Delhi is a union territory, and there is another center union territory tussle which goes on, and that you may have read about it. So there are different issues which we have to deal with in this particular question. So you can see UPSC means 2016 they have asked this question, not in prelims but in mains. Major cities of India are becoming vulnerable to flood condition. You have to discuss it. Now what is the context of this particular article? Delhi experienced heavy rainfall causing widespread waterlogging despite Delhi High Court's recent direction aimed at addressing this recurring issue. If Delhi High Court has given these direction, why things are not changing? Because there are multiple authorities, and this has been cited like police, law and order. If you see Delhi Union Territory jurisdiction, there are certain areas which are under the ambit of central government, certain areas or certain jurisdiction or certain authorities which are under the state government, and sometimes the blame game happens. Same thing is happening here also. Despite Delhi court's recent directions, there is lack of coordination among different authorities. So in April 2024, Delhi High Court mandated a single agency to manage all 22 open drainage. Like drainage system is an issue in Delhi, right? And here we are not going deep into details. What I'm trying to tell you via this article is lack of coordination, haphazard urbanization, how all these things are contributing to, even in Hyderabad, in high-tech city, if rain happens, you will see clogging, drainage system issues, and we need to address this, right? So various agencies like PWD, MC, DND, MCI and FC, they all are having like managing different drains, and that's why there is a challenge. There is a coordination challenge, and they are not properly coordinating among themselves. This is an issue not only confined to Delhi. Delhi is just any major city per se, you will be finding this issue, including Hyderabad. So haphazard and urbanization. What is the basic meaning of haphazard urbanization? Unplanned, unregulated and often chaotic growth of urban areas. You must have heard about something known as compensatory afforestation, where they are saying that they will cut 10 trees and then they will plant 1,000 saplings or something like that. Compensatory afforestation. Some people also say that this compensatory afforestation is nothing but an excuse to do haphazard urbanization, because like let's say there is a 10 tree which has grown to its full potential, you cannot replace it by planting 100 saplings. That is not equitable afforestation in any way or the other, right? So all these things, small things, contribute to haphazard urbanization. So city expand without proper urban planning, zoning regulations. You see lakes dying in Bangalore. So all these are examples of haphazard urbanization. Infrastructure strain. Haphazard urbanization has strained Delhi's infrastructure, particularly its drainage system, which struggled to cope with the increased runoff from paved structure. Then agencies' responsibilities. Multiple agencies are there and they manage different aspects of urban development and challenges, leading to coordination issues and inefficiencies. So hope you're understanding this issue, and there has to be proper coordination. There has to be like compensatory afforestation. If somebody is like, that is a very noble initiative, but you have to see to which extent via compensatory afforestation you are allowing deforestation. So there are so many things to cater to here. Conclusion. The article underscores how haphazard urbanization in Delhi has led to significant infrastructure challenges, particularly in managing drainage system and mitigating the impact of water logging on residents and environment, right? So there was a very interesting debate related to economic development and environmental conservation. And here also, when you're seeing haphazard urbanization, you're seeing a tussle between economic development and environmental conservation. And the people say that they both lie at the opposite end of the spectrum. But according to environmentalists and other scholars, no, there is a midpoint here where you can focus both on economic development and environmental conservation, that is known as sustainable development. So the solution of haphazard urbanization lies to a great extent on promoting sustainable development, and that's why you have sustainable development goals, 17 goals, 169 targets and everything. So it's not like they both are at the opposite end of the spectrum. They meet at a point, and that point is known as the point of sustainable development.